Hi, I'm Darren Epstein and I am a candidate attorney at PPM Attorneys. Today, I'm going to explain what elements make a contract valid and legally enforceable. A common issue that always arises are people claiming that the contract they have entered into is unfair and they do not wish to be part of it anymore. They then claim that for this reason, the contract is unbinding and cannot be enforced. A big reality shock comes when they are in front of a judge who awards a large amount in terms of damages against them. Contracts are agreements between two or more parties. A contract sets out the legal rights and duties of the parties. Contracts can either be written or oral. Both are valid, but for obvious reasons, however, written contracts are easier to prove and enforce. There are 6 basic elements of a valid contract. Number 1, consensus. Consensus means that the minds of the parties must meet on all material aspects of the agreement. There must be an actual meeting of the minds of the parties. Number 2, capacity. Capacity is when the parties to a contract have the legal capacity to contract. An example is a contract entered into with a minor will have no legal force as minors do not have legal capacity, such as a contract where a minor agrees to purchase a motorbike. Number 3, formalities. Formalities are where a certain type of agreement must be in a prescribed form in order for it to be valid. An example for this is a contract for the alienation of land, which must always be in writing. Number 4, legality. A contract must always be lawful, that is, not prohibited by statute or common law. For example, a written contract for the sale of illegal drugs or to commit a crime will not be enforceable. Number 5, possibility. A contractual obligation must be possible to perform for it to be valid. The general rule is that the impossibility of performance prevents the creation of obligations. An example is when there is a sale of an object that does not exist. Number 6, certainty. A general requirement for the creation of contractual obligations is that their contents must be certain or ascertainable in order for the obligations to be enforced. If a contract provides an equation to work out an amount owed to one of the parties by the other, the final amount will be ascertainable by the equation and the contract will be valid provided the other elements are present. It is always important to think before you ink. You are bound by your signature and must ensure that you fully understand all clauses and obligations in the contract. Whenever there is uncertainty, have your attorney look over the contract and advise you accordingly. For more good, clear, precise advice, contact us.